Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. What should you do if you're injured while on the job? Who pays your medical bills, your lost wages, when you're recuperating? What happens if you're injured by work-related stress, or if you have hypertension, or you have a heart attack on the job? Today we're going to answer these questions and others when we look at the area of workers' compensation. Our guests are Victor Pasternak. Victor is a partner in the law firm of Pasternak, Popish & Reif. Victor is also chairman of the New York State Trial Lawyers Association Workers' Compensation Committee, and he represents the injured employees. We also have with us Hugh O'Boyle. Hugh is a partner in the law firm of Foley, Smith, O'Boyle, and Weissman. Hugh is chairman of the Workers' Compensation Division of the New York State Bar Association, and he represents the employers and the insurance companies, so we have both sides with us. Hello, Victor. Hello, Hugh.
Hello, Alan.
Victor, why don't you just give us a broad view of what is workers' compensation? Who collects it?
Well, workers' compensation is an insurance program which exists in 50 states in the United States, which involves benefits for workers who are injured on the job. It usually involves an accidental injury or an occupational disease. And rather than being allowed to sue the employer for the injuries that are sustained, the 50 states of the United States developed the system. Historically, the workers' compensation system in New York is 75 years old this year. Instead of being allowed to sue the employer, the states developed a system which would provide for easy benefits, quick benefits to be paid to injured workers, which would supplement them during the period of disability. It also provides for medical coverage for any injuries that are involved, any kind of medical care or attention that is required because of the injury sustained on the job.
So if I'm injured on the job while I'm at the law firm, all my medical bills are paid, all my lost wages are paid?
The important distinction, Alan, is between off-the-job and on-the-job injuries. For most people, there are two kinds of insurance: workers' compensation for injuries on the job and disability benefits for off-the-job injuries. If you're hurt in the course of your employment for an on-the-job injury, yes, all your medical bills would be paid, and there is a wage substitution benefit which is paid.
Well, what if I'm really injured? Say I have a permanent injury to my left arm, and it's permanent. Do I get wages for the rest of my life, or what happens then?
Perhaps. There is a provision in the New York law for permanent workers' compensation benefits. And in some cases, people receive those benefits for the rest of their life.
Well, those benefits we're talking about, Victor, is that my salary? Do I get my salary back, or are they less than my salary?
No, the workers' compensation law does not pay you dollar for dollar your salary. The law will give you 2/3 of your average weekly wage. Now, the average weekly wage basically is the average salary that you earned approximately going from the date of the accident going back 1 year. So we determine what your average weekly wage is, and then the law will pay you 2/3 of your average weekly wage, but there are maximum rates that are payable.
Well, do I have to pay taxes on that?
No, any benefits you receive under the workers' compensation law are non-taxable.
Well, what if I'm going out to the bank for my employer, and I fall or I trip over the sidewalk? Can I get benefits then?
Coverage is very broad in workers' compensation. So in an example of a special errand, as you just gave, it would probably follow that that kind of an injury would be in the course of employment, and the person would be compensated.
What if I'm just going out for my lunch? I want to grab a sandwich for lunch.
Now, Alan, you're getting us into a gray area, and the probabilities are that you would not be compensated if you're on your own time for your lunch hour.
What about if I'm going to work, Victor? If I'm on my way to work and I'm in a car accident, do I get paid?
Well, the general rule is that going to and coming from work is not compensable. However, the wonderful thing about law is that there are many exceptions. So that depending upon the particular facts of a case, you may in fact be compensated for that auto accident on the way to work. If you were involved in going on an errand for your employer, stopping off somewhere first before you went to work, or based upon the category of employment that you were engaged in, so that if you were a salesman who did not have a fixed place of employment, you would be covered from the moment you left your house.
I've had people call me and tell me that I tried to get a doctor, I was injured on the job, and my doctor doesn't treat workmen's compensation cases. What does that mean, you don't treat workmen's compensation?
There are some doctors who just do not want to treat workers' compensation cases. They feel that the recompense that they receive is not adequate. But there are really many, many thousands of doctors in New York State who are what they call coded, who are able to treat workers' compensation cases and are willing to do so.
Well, explain to me, what do you mean that they're not compensated? Who pays them?
The insurance company, and only the insurance company, pays the doctor. An injured claimant, as a matter of fact, does not pay the doctor, and it's against the law for the doctor to take payment from such a claimant.
Well, how does an injured worker actually get the payment? Do I just go to any doctor who has a workers' compensation license and he treats me and he's paid automatically without due regard?
Well, you go to a doctor for treatment. The doctor will deal directly with the insurance carrier. What you was mentioning was that the doctor is not supposed to charge you a fee for the services that are rendered. The doctor is supposed to fill out a medical report, submit the report and bill to the carrier, and the payment is made directly between the carrier
To the insurance company?
the insurance company, rather, and to the doctor.
Let's say I need an operation. I had that fractured arm, and I went to two doctors. One doctor said I needed an operation, and the other doctor said, well, maybe you should wait 6 weeks. Well, what happens then? Do they have to get your approval before I get the operation?
Yes, they should get the approval of the employer or the insurance company before having that surgery. That's, of course, where someone like Victor Pasternak comes in. There can be a disagreement between two physicians, and then you could result in a dispute having to be resolved by the Workers' Compensation Board.
Wait a minute. There's a lot of disputes here. Meanwhile, my arm, I have to get an operation on my arm, and you're fighting back and forth, and you're passing papers, yet my arm might be healing, and I need that operation. How long does this take?
It can take too long, and that's one of the problems in the system, getting early resolution of these issues. But nonetheless, the system is set up to have hearings, to have testimony, and to have judges render decisions when it's necessary.
Well, how long does it take? My arm is broken.
The variation is quite large. It can be a quick resolution between the parties. Two lawyers can simply get together and agree on a resolution, or there could be a trial, and there could even be an appeal from the decision by the judge.
Victor, we're going to find out how long this takes right after this break. You're watching Lawline. Stay with us.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is, there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors, or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
The party's over. All over, one for the road. All over for the 25,000 Americans who die each year as the result of drivers who drink. Drivers who don't realize how little it takes to turn the average social drinker into a tragedy. So please, take this advice from this station and the members of the New York State Bar Association. When in doubt, don't start out.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all this lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
Hi, I'm Alan Schnorman. You're watching Lawline. Today's topic is workers' compensation. With us is Victor Pasternak, who represents injured employees, and Hugh Boyle, who represents the insurance companies and the employers. Victor, I asked you right before the break, when do you need a lawyer? How can you speed up the process?
Well, lawyers often interject themselves into the case before we go to the compensation board, which is the court. In the example that we had about the broken arm and that we needed immediate care and attention, very often what I would do would be to call the insurance carrier and say there's an emergency situation. We can't wait for a hearing. We can't wait for a dispute. So I would ask the insurance company to have a doctor examine the claimant immediately to verify the need for the surgery or the operation. Assuming it's a bona fide situation where surgery is in fact needed right away, then in most cases you will get immediate attention for your client. If there is an honest dispute and it is something that can wait, then of course, if we cannot resolve it between the office and on the telephone between the offices, then we will have to get a decision from the Workers' Compensation Board on the issue and perhaps bring down doctors from both sides to give their point of view.
Victor says bring down doctors from both sides. Let's assume we have a bill that the doctor is submitted for $100. And you, representing the insurance company, the employer, say, I don't think that was necessary and proper, what you did for that particular claimant. And you dispute it. Does the doctor have to take his time and testify before the board?
No. There's an expedited procedure for that kind of a problem, and there's an arbitration board set up, and the bill can be considered by that arbitration board, and the doctor need not appear. It's the more substantive problems of disability, where it's challenged, or the need for an operation where it's challenged, that would result in a trial with the doctor having to testify.
Well, in your experience, how many claims are challenged and how many claims go through?
I couldn't give you, Alan, a percentage breakdown because I don't know it. I think a small number of cases of the overall number of cases are actually controverted and put into a trial procedure.
I once went to a workers' compensation board, and all I know is I saw the room was packed with hundreds of people.
Well, I think the thing you have to recognize about New York State, and in this it's somewhat unique, is that New York is an interventionist state. It continues to hold hearings and supervise the handling of workers' compensation cases all the time, whether or not there's any kind of a controversy.
Why
So
is
a
that?
typical injured claimant in New York will be called to the compensation board. He will appear before a judge who will review his case simply to find out if everything that has happened in the case has been done properly.
Does the claimant have to go for a physical then also at the same time?
He need not, but in some cases it's in his best interest to do so. So he comes to a hearing. You told us before about an injury where he broke his arm. He may be sent out to a doctor employed by New York State to fix a scheduled loss, so he'll receive a certain award for his injury.
Victor, I assume there's some type of emergency procedures. If somebody is severely injured on the job, that the doctor can go right away ahead and fix the wound, fix the laceration, without getting all this approval.
Well, yes. Common sense dictates that there are just times when you cannot call an insurance carrier or wait for authorization. If somebody comes into the hospital with a heart attack, we don't wait to get approval. The doctor should attend to the patient, and we'll worry about the authorization and the need for the authorization later. If it's an emergency, a doctor can go ahead and treat without prior authorization.
Now, Victor, how does the employee pay your fee? How does that work?
Well, attorneys' fees in workers' compensation cases are a variety of the contingency fee arrangement. That means that by law, I cannot charge a client who comes into my office for advice or for an opinion. I cannot charge that client for any work that I do. An attorney's fee is regulated by the Workers' Compensation Board. If we go to a hearing and we're successful in obtaining benefits for the claimant, which that claimant has not already gotten voluntarily from the insurance carrier, then the judge will determine what fee the attorney should get. And that fee will be deducted from the additional funds that are secured for the client at the hearing.
Well, does a claimant need a lawyer? Can a claimant just go right to the Workers' Compensation Board?
Sure. He can go through the whole process, and he can submit himself to the system, and he can go without a lawyer. In my opinion, claimant is ill-advised to do that, but many claimants do, and do so successfully.
Are there certain types of cases that lend themselves to go without a lawyer,
Sure.
and certain types of cases that you must have a lawyer?
I said before, there are routine hearings that go on all the time, and the board, the State Workers' Compensation Board, reviews the handling of claims. Many of these injuries are simple injuries, finger injuries, toe injuries, short periods of time lost from work. That kind of injury often doesn't require the intervention of a lawyer.
Alan,
Yes.
I'm going to have to take issue with you on this point because when you go down to a compensation hearing, the insurance company or the employer will retain a highly qualified lawyer like UO Boyle to represent the interests of the employer or the insurance company, so that the lineup, so to speak, when you get to that hearing is that there's a judge, there's a representative of the insurance carrier. In many cases it would be someone like UO Boyle. And if it's a claimant without an attorney, it's just the claimant. And compensation has its own language, it's got its own system, so that if anybody has ever been a participant to a workers' compensation proceeding, very often if you go down, you really have no idea of what's going on. And that, by the way, that applies to lawyers who somehow delve into a case. They may get a case now and then and really are not that well versed in workers' compensation, but go down to represent a client. You can get lost in the maze of different nomenclature and the language that goes on, and the system works very rapidly, so that the hearings are usually very short in duration, and there are many hearings in one day. So I would say to any injured worker who is listening to this program, by all means, avail yourself of the services of an attorney.
It's like getting into a hurricane. It's sort of, you go down there and everything is quick, and certainly the insurance company has a lawyer, and everybody else knows what's going on, so you have to know what's going on.
Absolutely.
Of course, there are trained judges there who protect the interests of the claimant, and very often those small injuries, those minor injuries, are very routine, and there are no issues at all.
Well, does the judge, is he there to judge, or is he there to take the part of the claimant, Victor?
Well, it's true that there are judges, but in fairness to the judges, very often there is an issue that is presented from one point of view. For instance, a carrier may raise an objection, an insurance company may raise an objection to an award, may claim that the award should be less, so that it is really unfair to say that the judge at all times can be on the side of the claimant, can be the guardian of the claimant's interest, because that judge is really a decider of the facts of the case.
Victor, is everything scheduled such as if a person loses a finger, is there a particular schedule that says if you lose up to the first knuckle you get so much and so much?
Well, the statute contains what you call a schedule. A schedule really is a listing. The limbs of the body are treated in a different manner than the torso of the body. So the fingers, the arms, legs, the toes are given monetary amounts based upon the percentage loss of use.
If somebody loses an eye, is there a particular number that eye is worth approximately?
Yes, there is.
And how does that number compare to, let's assume the employer was guilty of negligence, and if that victim had a right to sue the employer, which he doesn't, but if he did, how would that compare to the amount you can get from a jury?
Well, workers' compensation is a no-fault system. And in theory, at least, in exchange for prompt care and treatment and prompt payment of benefits to help a worker immediately during the time of the injury, the worker, in essence, gives up the right to recover a more substantial sum of money, which would most likely occur if you could sue the employer.
I understand that, Victor, but
In the court
okay,
of
let's
law.
go to that eye. How much would a person get if their eye is poked out on the job by a machine? How much does
Well, that would
victim get
also
on that?
depend upon the
loss of vision is the test.
loss of vision is the test.
The degree of loss of vision in that eye is going to determine the amount that he's going to get. And by the way, Alan, if I may just interject, one of the main issues in New York State concerns a point that Victor just brought up, and that's the inability of the employee to sue his employer. One of the great legislative issues in this state, which calls for some reform, is the fact that many employees are now recovering from their employers.
We have to take a break now, but let's cover that right after we get back. You're watching Lawline. Stay with us.
My father taught me to steal and to pitch. Today I struck out 7 and stole home. I think Dad would have been proud. Coach was. He said he wished Dad had taken as good care of himself as he did of me and Billy. Billy won't talk about it, and Mom can't stop crying. I don't know what it's like to have a heart attack, except I can see it hurts. It hurts bad.
You can help prevent heart disease. We can tell you how. My father, Gordon McCrae, was one of the biggest stars in musicals. He was also an alcoholic. When I was little, I thought I could stop my dad from drinking. But only the alcoholic can do that. And finally, my father got help and stayed sober the last 7 years of his life. I was so proud of him. Alcoholism is treatable and preventable. Be alert to signs that you might need help, especially if you're the child of an alcoholic. For information, call the National Council on Alcoholism, 1-800-NCA-CALL.
Talking computers, high-speed braille printers, new technology helping blind and visually impaired people participate fully in today's computer age.
And removing the top of page.
For more information about putting high technology to work for blind people, write American Foundation for the Blind, National Technology Center, Box 111, New York, New York 10011. The American Foundation for the Blind.
Hello, you're watching Lawline. Today's topic is workers' compensation. We have Victor Pasternak with us. Victor represents the injured parties, and also Hugh O'Boyle. You represents the insurance companies, the employers. You were saying before the break about this in the legislature. What's happening now?
Well, because of a quirky case in New York State, a small percentage of claimants are able to recover money from their employers. This small percentage of claimants recover large amounts. There is a need in New York State to increase benefits. I think most fair-minded people agree to that. And one of the ways to do that would be to more equitably distribute the money that the small percentage of claimants get by suing their employers.
We were talking about the eye case before. Approximately, what does a person get if they lose an eye on the job? And what would they get if they lose an eye due to someone's negligence in an automobile accident?
Well, under the workers' compensation law, the loss of one eye is equal to 150 weeks of compensation, usually payable at the maximum rate of $150 a week. It can vary depending upon how much total disability is involved, but basically you would determine the award by multiplying $150 a week times 150 weeks, which comes out to approximately or exactly $22,500.
And in your experience, if somebody was injured due to someone's negligence in an automobile accident, what could they get?
Well, if you're talking about civil litigation, of course, the loss of an eye is a very substantial injury involving a very great loss, and it would not be unreasonable to assume that a substantial sum of
If
money...
I said $1 million, would that be out of line?
I don't believe so.
But, Alan, bear in mind that every injured employee retains the right to sue for his accident. So he can sue the world. He can sue anybody who causes it with certain statutory immunities,
Except
one
his
of which is employer.
Except his employer.
And there are certain other immunities, but basically his employer is immune from such a suit, in most cases.
What about if you're injured while you're working in a construction site? Is that any different, you?
Construction site injuries result in a great deal of civil litigation. Construction site injuries often result in substantial recoveries for injured employees, and that also happens to be one of the examples of what I talked about before.
Under the labor law.
Yes, under the labor law. And that's an example also where employers are often brought back into the litigation and end up paying a part of the judgment.
Well, what happens when you say they're brought back into the litigation? They can be...
Without getting into too much of the technicalities of it, there is a way in which an employer can be brought in as a third-party defendant and can end up paying a part of a recovery to a plaintiff. You talked before about the numbers. I recently spoke to an attorney who had secured a $27 million recovery in a liability case, and the employer and its insurance company paid 40%, or was found to be responsible for 40%.
Victor, let's get back to that stress-related injury. If somebody has a heart attack on the job, can he collect?
Well, if we can prove that the stress-related injury was caused by something at the job or on the job, yes, you can. There is provision. There are cases where people are involved in a very stressful situation on the job, and either that will manifest itself either in a psychic injury, like an emotional injury in response to the stress, or a physical injury, so that somebody can be under a great amount of stress and strain and get a heart attack, and we regularly establish those kinds of cases.
Well, what happens if he has the heart attack at home?
That's a problem, because if I were defending the employer or carrying that case, I would have a lot of questions about whether it was related to his employment.
Victor, what happens if the employee does not have workers' compensation?
Well,
insurance?
if the employer does not have workers' compensation, first of all, it's a violation of the criminal laws of the state of New York. But that does not end the situation, the problem for the employer. The employer is still responsible for the payment of the workers' compensation award, and if solvent, that employer will have to pay that award. Now, if the employer is not solvent or is not financially responsible, there is an uninsured employers fund, which basically is a fund to ensure that the injured worker is not left without benefits in the event that the employer does not have compensation coverage.
Well, if the employer doesn't have workers' compensation, he doesn't give you any monies, can you sue him then for negligence if he is?
As a matter of fact, you can, yes. And there is a provision under the law to allow a claimant injured in the course of work by an uninsured employer to sue.
Okay. Victor, let's take the example that an employee lifts up a box and injures his back. And he's got a bad back, and he has a bad back for years. Well, will the employer's insurance company pay him for all those years?
Yes. Assuming you can prove that the disability continues, that disability can extend for the lifetime of the injured worker.
What would you like to tell the audience regarding workers' compensation from the point of an employer?
I think, Alan, most employers that I know want to pay their employees the money that they're entitled to. They don't want to pay them more than they're entitled to, but they do want to compensate their employees for the injuries. I would discourage anyone from making claims that are tenuous, that didn't happen in the course of employment. I don't think most claims are that way, and I think it's better for labor relations in the state if the system works properly and people are paid their just benefits.
Victor, if all of a sudden I gave you the power of the legislature and you could do anything regarding workers' compensation insurance law, what would you do?
Well, the two obvious things are to increase the rate of compensation, because the rates of compensation that are presently in existence in the state of New York are really inadequate and antiquated. I would do that, and also change the dichotomy, the difference between total disability and partial disability. Now, under the law, there are two different categories.
We're going to have to cover that, obviously, in our next session.
Okay.
Victor Paxtonak, U.O. Boyle, thank you both for appearing on Lawline. This is Alan Schnorman, and as always, thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney, author and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Lawline, 27th floor, 63 Wall Street, New York, New York, 10005.